Hello, everyone, and welcome to Credit Card Debt Ends Here, the second episode in our series of podcasts. Welcome back, where we cut through the confusion, explain your rights, and help you understand your ground when you are faced with credit card debt, lawsuits, and aggressive collection tactics. I am your host, Evstathios Georgiou, the managing attorney at Georgiou Law here in New York City. But before we dive in, remember that this podcast is for informational purposes only and is not legal advice. Your situation may be unique, so please consult an attorney if you have a specific legal issue. Today, we will be talking about something every consumer should know about: your rights under the Fair Debt Collection Practices Act, or otherwise known as the FDCPA. This is a federal law that sets the rules for debt collectors, what they can and cannot do, and it gives you, the consumer, the tools to protect yourselves. Why does the FDCPA exist? Debt collection, when done lawfully, is a legitimate business function. But before the FDCPA was passed in 1977, there were almost no federal limits on how collectors operated. So Congress stepped in with the FDCPA to stop abusive, deceptive, and unfair collection practices. The law applies to third-party debt collectors, meaning companies or law firms collecting debts on behalf of someone else, or debt buyers who purchased your account. Key protections under the FDCPA. The FDCPA gives you specific enforceable rights. Let's walk through some of the most important. No harassment or abuse. Debt collectors cannot use obscene or profane language, threaten violence or harm, repeatedly call to annoy or harass, publish your name as someone who won't pay their debts. No false or misleading statements are permitted. They cannot claim to be an attorney if they are not, threaten arrest or legal action they cannot take, misrepresent the amount you owe, pretend to be a government agency. Communication rules. Debt collectors cannot contact you before 8 a.m. or after 9 p.m. unless you agree. At work, if you tell them your employer doesn't allow it. If you have an attorney, then in that case, they must contact the attorney. Your right to verification. Within 5 days of first contacting you, a collector must send a written notice with 3 things: the amount of debt, the name of the creditor or the bank, a statement of your right to dispute the debt. If you do dispute the debt in writing within 30 days, the debt collection agency must stop collection until they verify it. Your rights to cease communication. If you send them a written request and tell them to stop contacting you, they must stop, except to tell you they're ending collection or taking specific legal action. This is otherwise known as a cease and desist letter. Common FDCPA violations. Here's where the law gets real. Collectors violate the FDCPA more often than you think. Some examples that I've seen in my practice: calling a consumer's workplace after being told not to, threatening to sue on a time-barred debt. What that means is that the debt cannot be legally collected upon because the statute of limitations has expired. And in New York City, that's 3 years. Misrepresenting the balance by adding unauthorized fees, contacting family members and disclosing details about the debt. That's a big no-no. Failing to send the required written notice. Each violation can be grounds for legal action against the debt collector. Now, how do you document and enforce your rights, you ask? Well, If you suspect a violation, you should do 4 things. Keep a log. Record the dates, times, and content of the calls. Save all letters, voicemails, and emails. They may be evidence. Get caller IDs or phone records, which may be useful. What does this mean for you, the consumer? Well, FDCPA cases can be pursued without out-of-pocket legal fees. So the consumer does not have to pay for anything upfront. FDCPA in the courtroom. In a credit card lawsuit, FDCPA violations can be very powerful. If a collector has broken the law while pursuing your account, it can shift the dynamics of the case. Documented violations to get cases dismissed, negotiate favorable settlements, or even file counterclaims. It protects you from harassment, deception, and unfair practices by debt collectors. You have the right to demand verification, control how and when they contact you, and take legal action if they violate your rights. Documentation is your best friend. Without it, it's your word against theirs. If you're dealing with aggressive debt collection in New York City, don't wait for it to escalate. Call Georgiou Law now at 917-764-3072 for your free consultation. I'll evaluate your situation, explain your rights, and take action to protect you.